Hey, you passionate people out there, it's me, Dhritikathuria. In this video, we will be doing another important topic of constitutional law. That important topic is citizenship. So, let's get started. Starting with what is citizenship? Citizenship refers to the full membership of any state or country in which a citizen have both the political and civil rights. It is basically a legal relationship of a person with the nation. Citizenship can also be defined as status of a person recognized under law as being a legal member of a sovereign state or a nation. Now let's talk about the constitutional provisions for citizenship. The Constituent Assembly incorporated or added a provision through Article 11 to regulate citizenship in India. When the Constituent Assembly adopted this constitution, they brought Part 2 of the Constitution in force, which focuses on the citizenship of India. Article 5 to 11 of the Part 2 of the Constitution deals with it. So let's talk about them in detail. Article 5. It states that every person who has a domicile in the territory of India, मतलब कोई भी जो इंडिया में permanently रहता हो, who was born in the territory of India, कोई भी जिसका जन्म इंडिया में हुआ हो, either of whose parents were born in the territory of India, कोई भी जिसके पेरेंट्स का जन्म इंडिया में हुआ हो, who has been ordinarily resident in the territory of India for not less than 5 years. कोई भी जो इंडिया में कम से कम 5 साल से रह रहा हो आर कॉल्ड अ सिटीजन ऑफ इंडिया. आर्टिकल 6. Right of citizenship of certain persons who have migrated to India from the territory now included in Pakistan shall be deemed to be a citizen of India at the commencement of this constitution. मतलब कि राइट ऑफ सिटीजनशिप ऑफ इंडिया हर उस व्यक्ति को मिलती है जिसने माइग्रेट किया हो उन टेरिटरीज से जो करेंटली पाकिस्तान में है टू एनी टेरिटरी ऑफ इंडिया सिंस द कमेंसमेंट ऑफ दिस कॉन्स्टिट्यूशन. Article 7. Rights of citizenship of certain migrants to Pakistan is a special provision for persons who have migrated to Pakistan after 1st March 1947 but returned to India subsequently. Article 8. Right of citizenship of certain persons of Indian origin residing outside India for the purpose of employment, education or marriage. मतलब कि राइट ऑफ सिटीजनशिप ऑफ इंडिया हर उस व्यक्ति को मिलती है जो इंडियन ओरिजिन का हो पर किसी स्पेसिफिक पर्पस की वजह से बाहर आउट ऑफ इंडिया रह रहा हो. दोज रीजंस कैन बी एजुकेशन, एम्प्लॉयमेंट या फिर मैरिज. Article 9. Persons who have voluntarily acquired citizenship of a foreign state or country will not be a citizen of India. मतलब कि जो भी व्यक्ति अपनी मर्जी से किसी फॉरेन कंट्री या स्टेट की सिटीजनशिप ले लेता है वो इंडिया का सिटीजन नहीं रहता. Article 10. Every person who is a citizen of India under any provisions of this part will be subject to any law enacted by the parliament. मतलब कि हर व्यक्ति जो इंडिया का सिटीजन है चाहे वो इंडिया में रहता हो या नहीं उस पर वो हर लॉ लगेगा जो नया आएगा. Now we'll talk about Citizenship Act of 1955. It basically deals with the acquisition and termination of citizenship after the commencement of the Constitution. Just like every act, this act also has some provisions such as anyone who is born in India after 26th of January 1950 would be a citizen of India except those children of diplomats. Anyone who is born after 26 January 1950 would be citizen of India subject to certain requirements. Certain categories of citizens can acquire citizenship by registration in the prescribed manner. Foreigners, that is, anyone living outside India, can acquire Indian citizenship by naturalization process. If any territory becomes a part of India, the government could specify the conditions for them to become a citizen of India. Citizenship could be lost by termination, renunciation, deprivation on certain grounds. Citizenship of a Commonwealth country would have the status of a Commonwealth citizen in India. The Citizenship Act has been amended many a times. Each amendment had some specific mention for which they were amended. The amendments were made in the following years: Citizenship Amendment Act of 1986, Citizenship Amendment Act of 1992, Citizenship Amendment Act of 2003, Citizenship Amendment Act of 2005. So let's talk about them in a bit of detail. Citizenship Amendment Act of 1986. This amended act specifically deals with the citizenship of the state of Assam. It basically mentions about those illegal migrants to get citizenship when they need to be registered with the Indian consulate in the prescribed manner. Citizenship Amendment Act of 1992. Through this amendment, it was said that any person born outside India is considered a citizen of India by virtue of citizenship by descent if either of the parents was a citizen at the time of his or her birth. Citizenship Amendment Act of 2003. With this amendment in the Citizenship Act, several provisions for overseas citizens regarding their registrations, right in India, etc. were introduced. Citizenship Amendment Act of 2005. This amendment is based on the recommendations of the Parliamentary Standing Committee on Home Affairs. It basically provides for dual citizenship to persons of Indian origin of 16 countries. Coming to the mode of acquisition of citizenship in India. A citizenship can be acquired through various means such as by birth. According to this clause, अगर मेरा जन्म इंडिया में हुआ है या फिर मेरे जन्म के टाइम मेरे कोई भी एक पेरेंट इंडियन सिटीजन है तो मैं इंडियन सिटीजन हूँ. But this is subject to change according to the amendment in place at that time. By registration. According to this clause, मैं citizenship ले सकती हूँ through the process of registration. Thirdly, by descent. According to this clause, अगर मेरे दोनों पेरेंट्स या कोई एक पेरेंट भी citizen of India है, not being an illegal migrant, तो I am a citizen of India. Next, by naturalization. According to this clause, any foreigner can apply for the citizenship of India. Fifth point, by incorporation of territory. According to this clause, अगर कोई टेरिटरी इंडिया का पार्ट डिक्लेयर होती है तो उस टेरिटरी में रह रहे लोग भी इंडियन सिटीजन बन जाएंगे, only with the reasons that they have connections with the territory. Loss of citizenship in India. The Citizenship Act of 1955 deals with the loss of citizenship and also with the acquisition of citizenship. It can be carried or lost firstly by renunciation. Renunciation means कि एक व्यक्ति ने अपना सब कुछ त्याग दिया है and वो संन्यास ले रहा है. So, if any person who has made a declaration stating his willingness to renounce the citizenship shall cease to be the citizen of India. Second way is by termination. In this clause, if a person voluntarily or knowingly becomes a citizen of any other foreign country, he loses the citizenship of India. Thirdly, by deprivation. If a person has been ordinarily resident or out of India for a continuous period of 7 years, he also loses the citizenship of India. Now we'll talk about those important terms which are widely used in the Citizenship Act. Those are persons of Indian origin, PIO, non-Indian resident, NRI, Overseas Citizen of India, OCI. Persons of Indian origin, PIO. A PIO is a person whose parents or grandparents are citizens of India, but he is not a citizen of India. Non-resident Indian, NRI. An NRI is a citizen of India who holds an Indian passport and has temporarily immigrated to other countries, either for employment or education or any other purpose. Overseas Citizen of India, OCI. According to the Citizenship Amendment Act of 2003, an overseas citizen of India includes a person of Indian origin who was citizen of India immediately becoming a citizen of any other country. They are registered as OCI by the central government. Hold on, don't forget to subscribe. Thanks for watching.